Good afternoon, and welcome to the American Constitution Society's annual Supreme Court preview. My name is Russ Feingold, and I'm the president of ACS, the country's foremost progressive legal network with more than 200 student and lawyer chapters across the nation. ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers, judges, and advocates, and ensuring that the law is a force to improve the lives of all people. We are focusing our work in this anniversary year on our Constitution's founding failures when it comes to race and equality in this country. And if you don't already, we encourage you to follow us on social media and online at acslaw.org. This last weekend marked a much less happy anniversary. The first year since Supreme Court Justice Ruth Bader Ginsburg passed away. And so ACS has established a new award in her honor. 50 years ago, when the Supreme Court handed down its decision in Reed versus Reed, holding for the first time that the Equal Protection Clause prohibited discrimination on the basis of sex, it was Professor Ginsburg's brief that won the day. It is therefore fitting that the annual Ruth Bader Ginsburg Scholar Award will recognize an outstanding junior scholar whose work is helping to make society more just and more equal. It will be presented at our national convention next June, along with a prize of $5,000. I hope you will help us spread the word. Details can be found on our website. Of course, Justice Ginsburg's presence on the court is most sorely missed as we head into a new Supreme Court term, where women's equality hangs in the balance. The court's highest charge is to uphold constitutional rights. When it allowed Texas's notorious SB 8 prohibiting abortion after 6 weeks to go into effect, it failed in its mission. Perhaps it should be no surprise then that calls for court reform are increasing in intensity every day. All eyes will be on the court this fall. And I look forward to hearing our illustrious panel today tell us more about what we should be looking for. To get us started, it is my great pleasure to introduce our moderator, CNN legal analyst Joan Biscuit. No one knows more about the court or the justices than Joan. She has covered it for 25 years and is the author of books on Chief Justice John Roberts, Justices Sandra Day O'Connor, Antonin Scalia, and Sonia Sotomayor. Before joining CNN in 2017, she was an editor in charge for legal affairs at Reuters and previously the Supreme Court correspondent for the Washington Post and USA Today. She was a finalist for the Pulitzer Prize in Explanatory Journalism in 2015. And Joan holds a law degree from Georgetown University. So Joan, please take it away and thank you.
Thank you, Russ. And thanks to Kara Stein for getting us organized. It's exciting to be here at the start of a new session, especially since we're seeing a sea change at the Supreme Court. Normally, we have a quiet summer before sessions. The justices often joke about how much they need the summer recess to let their temperatures cool. But this summer was anything but quiet. We saw orders in the challenges to the Biden administration policy on U.S. asylum policy and the eviction moratorium tied to COVID-19. And of course, as Russ just mentioned, on September 1st, we saw the court let the Texas abortion case take effect. It feels like we're on the cusp of an even bigger shift at the court with 6 conservative justices, 3 of them Trump appointees. Chief Justice John Roberts ended up siding with the liberals, of course, in the abortion case. He was protesting the hasty action the majority was taking. And that raises a question of how much influence he will have on the bench in this upcoming very pivotal term. For decades, the contemporary court was split 5-4, with at least one centrist conservative straddling the middle and moderating the law. Now we have this 6-3 court. To consider the consequences of this court and major cases in what is likely to be a pivotal term are 5 experts in their fields covering abortion rights, guns, state secrets, capital punishment, and religious liberty. I'm going to introduce them in the order that they will present their cases later as we get rolling, and you'll start to see their faces on the screen here. Jennifer Dalvin is the director of the ACLU's Reproductive Freedom Project. She oversees and directs the ACLU's litigation, state advocacy, and communications work on issues affecting access to reproductive services. She has successfully litigated numerous reproductive rights cases around the country and argued at the Supreme Court, Planned Parenthood versus Ayotte, challenging New Hampshire's parental notice requirement for abortion. She graduated from New York University Law School and served as a law clerk to Judge Pierre Laval of the Second Circuit. Shay Dvoretzky is a partner at Skadden, Arps, Slate, Meagher, and Flom, and head of the Supreme Court Appellate Litigation Group there. He has argued 13 cases at the Supreme Court. His work has covered constitutional law, administrative law, antitrust, arbitration, bankruptcy, labor, and employment. He graduated from Yale Law School, clerked for Judge Michael Luttig on the Fourth Circuit, and also for Supreme Court Justice Antonin Scalia. Alexis Hogue is an assistant professor at Brooklyn Law School. She specializes in criminal law. Her scholarship examines the ways in which policies and practices within the criminal system can erode people's constitutional rights and perpetuate discrimination. She graduated from NYU Law School, where she was a Derrick Bell Public Interest Scholar. She served as a law clerk to Judge John T. Nixon of the U.S. District Court for the Middle District of Tennessee. Daryl Miller is the Melvin G. Shimm Professor of Law and Associate Dean at Duke University Law School. He teaches in the area in civil rights, constitutional law, civil procedure, state and government law, and legal history. His scholarship on the Second and 13th Amendments has been cited by the U.S. Supreme Court. He's a Harvard Law graduate, and he was a law clerk to Judge R. Guy Cole Jr. of the Sixth Circuit Court of Appeals. And then we have Aaron Tang, law professor at UC Davis School of Law. His teaching and research interests include constitutional law, federal courts, education law. His writings have appeared in the New York Times, Washington Post, LA Times, and Atlantic. He graduated from Stanford Law School and clerked for J. Harvey Wilkinson on the Fourth Circuit, and then was a law clerk to Justice Sonia Sotomayor. Thanks to all of you panelists for sharing your expertise, and to those of you watching. Each of our panelists are going to present key cases, and the other panelists will be welcome to jump in with their own commentary as we do that. And we're going to begin with abortion rights, which of course is so timely right now. But before we get to the real meat here, I thought we'd ask each of our experts to just briefly state what they might be watching for as we begin this historic term. You know, this is going to be the first time they'll be in the courtroom since March of 2020. It's the first full term with Justice Amy Coney Barrett, perhaps the last with Justice Breyer. We'll have to see. Abortion is on the agenda in the most serious challenge since the 1992 Planned Parenthood versus Casey dispute. And I just think at this moment, it would be good just to have a couple sentences, very brief from each of our panelists, so you can just hear them speak all together at the outset here about what they'll be watching for. I have to say, for my part, I will be so excited to return to the courtroom and to see the 9 arrayed on the bench, to see in person Justice Barrett for the first time. Of course, I've seen her, from the hearings and in some public appearances, but this will be the first time in the flesh. I'm eager to hear what their questions are, how they relate to each other, and just interact for the first time in all these months. And now I ask what the rest of you might be looking for, and I'll start, Aaron, with you. What in particular will you be watching for as the court term begins?
Sure. So what I'll be looking for is that I think this term will reveal, maybe conclusively, whether this new court that you all have alluded to with its 6-3 conservative supermajority is a far right court or a center right court. right? I think right now the tea leaves are kind of mixed. Surely in some cases, SB 8, Jackson, we've talked about voting rights. You could make a very strong case that the court's already gone far to the right and then it's, game over. But then if you look at other recent cases having to do with LGBTQ rights, the Affordable Care Act, it's been maybe more center right. And I don't think there'll be any doubt after this term, because the conservatives have before them sort of legally viable ways to decide the two biggest cases on abortion and guns this term that in ways that are sort of moderate or center right, or they could lurch far, far to the right. So we'll know this time next year which kind of court we have. And I think that's going to help progressives finally form a judgment on whether some of the more extreme court reform proposals we've talked about might be the lesser of two evils compared to, maybe a far right court.
Thanks, Aaron. Alexis?
Thank you, Joan. I think Aaron is slightly more optimistic than me. The court has always been about flexing political power, advancing ideology. It's really baked into the institution. So as much as Chief Justice Roberts may want it to appear otherwise, I think what I'm looking for is these stark divisions. And I think we're going to see them along political lines on hot button issues. And that's, of course, all the cases that we're discussing this afternoon. I think we'll continue to see lengthy dissents. This is what I'll be looking for from Justice Sotomayor. She's crafting arguments for future advocates. She's creating these roadmaps for how to restore rights to disempowered people, which is what we have seen being stripped away this most recent term and in recent history. So I'm looking for lengthy dissents, a roadmap from Justice Sotomayor.
Thanks. Darrell?
Yeah, I think I would just echo what Aaron and Alexis said in the sense that Mitch McConnell made a big bet in terms of blowing through a bunch of norms about the appointment of Supreme Court justices of a president of a different party. And this is the term that really is going to see whether that was a bet that it's going to pay off for Republicans and the Federal Society, or if some kind of rule morality that the justices have been emphasizing recently about not being a political court, about being a court that's bound by the rule of law and precedent, whether that's actually going to be true or not.
Thank you. Jennifer?
I'm just going to quickly sort of follow up on the comments of my colleagues here, and I just put a finer point on it. I'm going to be watching Justice Kavanaugh. I'm going to be watching what he does on those issues that others have highlighted, questions about stare decisis, questions about the integrity of the court, and how closely or not he is aligned with the chief.
Thanks. And Shay?
Thanks, Joan. I'll highlight 2 points that I'm looking forward to or interested in from a Supreme Court practice point of view. One is the size of the court's docket, and the other is how the oral arguments are conducted. Last term, the court issued 54 signed opinions. That's the second lowest number since the Civil War. I'll be interested to see if the court starts granting more cases or whether they have settled into their current pace as kind of a new normal. The other thing is I'll be interested to see how the questioning goes when the justices get back together in person. During the last term and a half, the court was conducting arguments telephonically using what is for them a very unusual and rigid sequential questioning format. That had some downsides, but it also had some real benefits in terms of getting a chance to hear from all of the justices. And it'll be interesting to me to see if the court adopts some version of that going forward, or whether things go back to the same free-for-all format that we're all used to.
Well, Shay, they heard your question because just this morning they issued a note to counsel explaining that they'll do a bit of a hybrid there. Counsel will still have 2 minutes to present a case, and then the justices will jump in, but there will also be time reserved for the justices to go in order of seniority to ask any lingering questions. So it'll be an interesting format, and I'm eager to see how they're able to keep to relatively 1 hour arguments under that format. But I think it's a good way to ensure that maybe Justice Thomas gets a chance to speak still, but we can talk more about that at the end. But yes, just the sheer dynamic of oral arguments will be fun to watch.
Yeah, and that's great from an advocate's perspective, because as an advocate, you don't get to answer the questions that you're not asked. So having that kind of reserved time at the end where everybody gets to air their questions is great.
That's right. That's right. Okay, so now we're going to go in a predetermined order, but I'm going to encourage the panelists to jump in after the main presenter has explained her case or his case, and just so we can have a little back and forth once the largest issues are explained. And we're going to start with Jennifer Dalvin, and she has the issue that's has been on everyone's mind since before September 1st, but especially since September 1st. And the case that we now know will be heard on December 1st is Dobbs versus Jackson Women's Health. And the question that the justices took the case on is whether all pre-viability prohibitions on abortions are unconstitutional. There were a couple other questions that were presented that they said they were not going to take. But Jennifer, why don't you explain the case, and feel free to touch as much as you want on what's happening in Texas.
Yeah, great. Thank you so much, Joan. And I'm happy to talk about both the Mississippi case, Jackson Women's Health, and the Texas case. And Joan couldn't be more right. This is an absolutely critical time for abortion rights. I've been doing this work for more than 25 years, and access to abortion has never been more at risk. For the first time in a generation, as Joan said, the court will hear a direct challenge to Roe versus Wade. And at the same time, we've got Texas out there making Roe versus Wade all but irrelevant for people by banning abortion in a very tricky way that makes it very challenging to challenge in court. So I'm going to talk a lot about the law, but I just do want to pause for a minute, because I think sometimes when we do that, when we focus so much on the nitty-gritty of the law, we lose track of who these laws affect and what their real world impact is. And, 1 in 3 women will have an abortion in their lifetime. And for a lot of people who live in, the coasts and different, some parts of the state, some parts of the country, and people who have means, they will always have access. But right now, including right now in Texas, it is the case that the only way to get a medically supervised abortion after the first few weeks of pregnancy is to literally travel hundreds and hundreds of miles. And what that means is, for many people, it's just not a reality. You can't get the time off of work. You don't have paid leave. You don't have reliable transportation. You don't have somebody to watch your kids. You're a victim of domestic violence. And as a result, people are having kids that they weren't planning to have, that they don't feel prepared to have. And this impacts people of color, young people, people without resources, undocumented folks the hardest. So I just want to say that at the beginning, so we don't lose sight of that when we start talking about the nitty gritty of the law. But the Mississippi case is a case in which Mississippi banned abortion at approximately 15 weeks of pregnancy. Clearly unconstitutional. The district court knew this. Even the Fifth Circuit, which is no friend to abortion rights, struck this law down as clearly unconstitutional. And that's because for 50 years, the Supreme Court has said that you can't ban abortion before viability, before the fetus can live outside the woman's body. And no one disputed that the Mississippi law took effect months before that could happen. So Mississippi predictably loses at the district court and the Fifth Circuit level. And then they petitioned for cert back in 2020. And the reason I mention that is because in that cert petition, they don't say overturn Roe. They try to argue there that the 15-week ban is consistent with Roe. Then you fast forward a year when the Supreme Court grants cert. And Mississippi submits its merits brief. And in the merits brief, all they argue pretty much is that Roe was wrongly decided, Casey was wrongly decided, and has to be overturned. They only give a very half-hearted argument at the very end that this law could be upheld even if the court doesn't overturn Roe v. Wade. So that's pretty remarkable. It's pretty remarkable. And there's a very clear reason for that change in strategy, right? The only thing that is different now is the composition of the court, right? Justice Ginsburg has died. Amy Coney Barrett has taken her spot. And so now they are asking for something completely different. And all of the arguments that were put up by Mississippi about why Roe should be overturned were arguments that were rejected in Casey back in 1992. And yet they're trying again. If the court goes forward in this way, if it overturns Roe v. Wade, it will be I think, tremendous blow to the court's legitimacy. I think it will be quite something to note that if the court decides that it can now turn its back on 50 years of precedent that has been reaffirmed over and over again. The other thing I would note about this brief is, as I said, it all but gives up on this argument that you can uphold a 15-week ban without opening the door to states banning abortion earlier and earlier. It cites the same state interests. Mississippi also passed a law banning abortions at 6 weeks in pregnancy, making the same arguments. And so I think those are the two things that are really remarkable about the brief. The court might still try to find a way to go between that, not overturn Roe versus Wade. I don't think Chief Justice Roberts is anxious for a headline that says Roe v. Wade is overturned. But I would submit that if they do that, it would be unprincipled. And it would open the door for further and further bans and a tremendous explosion in abortion litigation. I'm going to take a breath there if anyone wants to jump in, and then I'll turn to and then I can turn to Texas.
Why don't you go right into Texas?
Okay,
and one thing, Jen, that I want to mention, we got a question that asked specifically about that the mechanism that bars government officials from being sued. So just touch on that as you
definitely talk about that. Yes, that's exactly right. So coming to Texas, right, we're talking about Roe v. Wade potentially getting overturned in the Mississippi case, but Texas has already jumped the gun. They're not waiting for the Supreme Court to act in that way. So Texas recently passed a law that Chief Justice Roberts called not only unusual, but unprecedented. It bans abortions as early as 6 weeks of pregnancy before many people know they're pregnant. Sadly, that part isn't unusual. As folks might remember, after Justice Kennedy retired, a number of states started passing laws banning abortion at 6 weeks, but those laws are clearly unconstitutional and were blocked in the courts. What's so unprecedented and deliberately so is the enforcement mechanism. What Texas did is said, we, the state, are not going to enforce this law. Most abortion bans are criminal bans or have very clear licensing penalties. That's not what Texas did. Texas outsourced the enforcement of this law. It set up a bounty hunting scheme. It said that anybody can sue any abortion provider who provides an abortion after 6 weeks of pregnancy. It could be your neighbor. It could be your estranged relative. It could be your ex-boyfriend. It could be an anti-abortion activist, can sue the abortion provider for a minimum of $10,000 per abortion. In addition, they can sue anyone who, quote, aids and abets the abortion. So anybody who helps the person who get an abortion can get sued, whether you give them money, give them a ride, all of those folks are subject to suit. And so a number of legal organizations, including the ACLU, Planned Parenthood, the Center for Reproductive Rights, the Lawyering Project, all went to court on behalf of a tremendously brave coalition of abortion providers, abortion funds, lawyers who help minors on the ground in Texas. And we sued. And because this is ACS, I'll go get a little into the nitty gritty. We sued a number of defendants. We sued state court clerks. We sued state court judges, a class of them. We sued state officials who were empowered to take licensing actions after violations of laws were found. We sued an individual from Texas Right to Life who was out in front threatening to sue people. But you're exactly right, Joan. The question you mentioned, the defendants moved to dismiss the case based on sovereign immunity grounds. The district court issued a wonderful, thorough opinion denying that motion. The defendants very, very quickly went up to the Fifth Circuit, and the proceedings were all stayed. And so quickly thereafter, we went up to the Supreme Court. And as you mentioned, we lost there. We lost in what Justice Sotomayor called a stunning opinion by a 5-4 vote. The court refused to stay the law. They did not rule on the merits of the case. They just refused to get in at this point. They made very clear that they weren't ruling that this law was constitutional and that further challenges and even this litigation couldn't proceed. But I think Justice Sotomayor's words were really quite extraordinary. She said, the Texas Act is a breathtaking act of defiance of the Constitution, of this court's precedents, and of the rights of women seeking abortions throughout Texas. It cannot be the case, she continued, that a state can evade federal judicial scrutiny by outsourcing the enforcement of unconstitutional laws to its citizenry. As you said, Joan, the chief joined with the 3 liberals. But the end result is the law is in effect, and it has been for 21 days. And the effects are devastating. I'll just give you a few examples. One woman piled her kids into her car and drove more than 15 hours overnight from Texas to Kansas just to obtain an abortion. A minor from Galveston who was raped by a family member traveled 8 hours to Oklahoma to terminate her pregnancy. Another patient made the 6-hour trek for an out-of-state abortion alone, fearing that anybody who was in the car with her could get sued. And these are the lucky ones. These are the people who actually got abortion care. But as I said at the beginning, so many other people who can't take the time off work, don't have the money, don't have childcare, aren't able to get that care. So that's what's happening right now. Folks may have seen that DOJ brought a complementary lawsuit, which was very exciting to see. They don't, because it's the federal government suing, they don't face quite the same sovereign immunity questions that the private provider suit does. But the hearing on that case, unfortunately, won't be until October 1st. And so all the while, the law remains in effect. I can leave you with one bright spot, which is that Congress is voting on a bill, the Women's Health Protection Act, which would provide a federal right, a new federal right to safeguard abortion access. And that's happening for the first time this week. So I'll try to leave folks on one bright spot.
Thank you, Jennifer. We've gotten 1 or 2 questions related to that. They're a little bit kind of in the weeds, but before I get to those, I just want to see if any of the other panelists want to jump in any way. Just unmute yourself when the time comes.
So I have a question.
Darrell, yeah.
Yeah, and this really has to do with, I wonder if you could speak a little bit about the asymmetry. Like if this kind of bounty system is upheld, what is to keep what we might think of as a blue state, California, New York, from enacting its own set of bounties on whatever public policy that it thinks that the Supreme Court got wrong? I'm a gun rights scholar, so I can imagine something about guns, but you could talk about transgender rights or women's rights or any one of a number of things. So what's the hazard that blue states might get in the bounty game?
That's exactly right. And thank you for raising that important point. This can go both ways, right? This can go, you can imagine California adopting a law that says, okay, we know we can't restrict gun ownership in this way, but we're going to leave it to your neighbor to bring you to court if they find that you have a gun that isn't licensed in the home or something like that. So there is nothing that stops this from going both ways and also spreading from state to state.
Jen, let me just ask one of the questions that's come in. Can the Texas law be invalidated on standing? Go ahead.
So if by that you mean why is it the case that someone who has no injury might be able to sue a Texas abortion provider?
Right. What would be the injury for the bounty hunter?
Right. The Texas law specifically tries to say that there is no injury needed. So there are some real questions about Texas state law about whether that's okay under the Texas Constitution, and that's being raised in other litigation as well. But that's a real question. But it is not a question in the federal lawsuit.
Great. Thank you. Thank you so much for that. And at the end, we'll probably come back to questions on abortion because it's such a major issue right now. But the next one, Shay is going to talk about the 2 state secrets cases. And it's so unusual to have even 1 state secrets case up there. And we've got 2 this term. If you could explain it and just talk about the basic principle we're talking about here, where the government says, because of national security interests, we're not going to be able to present this information. Shay?
Sure. Thanks, Joan. And as you mentioned, it is unusual for the court to hear even 1 state secrets case, let alone 2. This is the first time in a decade that the court has granted cert in this area. Let me start out talking about the first one, which is FBI versus Fazaga. And the question in this case has to do with the interplay between the state secrets privilege and whether the government can invoke it in order to force the termination of litigation, and Section 1806F of FISA, the Foreign Intelligence Surveillance Act of 1978, which governs the use of information obtained or derived from electronic surveillance for foreign intelligence purposes. Specifically, the question here is whether Section 1806F displaces the state secrets privilege. If it does, as the government argues, if it does as the plaintiffs in this case argue, then it would authorize a district court to resolve in camera and ex parte the merits of a lawsuit challenging the lawfulness of government surveillance by considering the privileged evidence. Let me tell a little bit about the factual background here. The plaintiffs here are 3 Muslim men who claim that from 2006 to 2007, the FBI used a confidential informant in order to illegally spy on them based solely on their religion. They brought a class action against the government and against the FBI officials, and they asserted both religion claims as well as search-related claims under a variety of different constitutional provisions. At the district court level, the government invoked the state secrets privilege, claiming that there was highly sensitive information at issue here and that supported dismissal of the religion claims. The district court responded to that by agreeing with the government's invocation of the privilege and dismissing not just the religion claims, but all of the claims in the case. The Ninth Circuit on appeal reversed. It held that Section 1806F of FISA provides procedures for actually adjudicating the legality of challenged electronic surveillance. And you adjudicate the legality through ex parte and in-camera review by the district court, and that those procedures replace the common law state secrets privilege. According to the Ninth Circuit, although the state secrets privilege has certain constitutional roots and overtones, at bottom, it's an evidentiary rule. It's rooted in the common law. And as a common law evidentiary rule, it can be overruled by statute. And that is what Congress did in 1806F. It intended to make that statute the exclusive means for deciding these sorts of claims. The government sought cert, essentially emphasizing the national security implications of all of this. In the government's view, first of all, Section 1806F isn't triggered on these facts by the terms of the statute. But in any event, even if it were, in the government's view, properly invoked, that doesn't displace the state secrets privilege. Full disclosure, I filed an amicus brief in this case on behalf of Professor Laura Donahue at Georgetown, who is an expert on FISA and on the state secrets privilege. The brief canvasses the history of the privilege in order to show that it really is an evidentiary privilege rather than a doctrine that has traditionally been used in order to terminate litigation on the merits. Now, of course, sometimes when you exclude evidence and what you've excluded is the critical evidence in the case, that may lead to the termination of the case because the plaintiff at that point no longer has a leg to stand on. But historically, the state secrets privilege has not included dismissal as a remedy. And the government is trying to do something here that, at least until recent years, was quite unusual. And that is to get the case terminated at the outset simply because the subject matter of the case is particularly sensitive. This case could have far-reaching implications for the government's ability to use claims of secrecy to shield itself from litigation in a variety of different contexts. It's not just limited to the surveillance context, but depending on what the court says about the state secrets privilege, it could become a powerful tool for the government to terminate at the outset litigation over other constitutional violations, over potentially sensitive breach of contract disputes with the government, employment discrimination claims involving sensitive jobs within the government, patent disputes. This could have far-reaching implications, again, for the government's ability to claim secrecy as a basis for avoiding litigation altogether. This case is going to be argued on November 8th. And before that, on October 6th, the government is going to hear argument in another state secrets case. This one is United States versus Zubaida, and it also comes from the Ninth Circuit. This one, I think, presents a little bit less of a clean, far-reaching legal issue. And reading the government's cert petition in this case, it feels a little bit more like just a request for error correction based on the facts of this case. So let me tell you a little bit about the facts of what happened in this case. The plaintiff here is a former associate of Osama bin Laden, who was detained abroad after his capture in Pakistan and who's now being held at Guantanamo. He alleges that before he was transferred to Guantanamo, he was held at a CIA dark site in Poland, where he was subjected to illegal interrogation techniques. Through his attorneys, he is now seeking to compel production in the United States by the CIA of information to be used in connection with a Polish criminal investigation into the CIA's conduct in that country. The government declassified some of the information about his treatment in CIA custody, but it protected other information as privileged state secrets. And the Ninth Circuit second-guessed the government's determinations and ordered additional information be made discoverable beyond what the government was willing to produce. According to the plaintiff in this case, the Court of Appeals properly disentangled the sensitive from non-sensitive information, and courts don't owe blanket deference to the government on its invocation of the state secrets privilege. But according to the government, the Ninth Circuit should have deferred to its determinations. And again, I think that the government views the Ninth Circuit's repeated undermining of the state secrets privilege as a threat to national security. So those two twin cases will be before the court this term. I think especially Fazaga has broad implications for the government's ability to use the state secrets privilege, and it'll be interesting to see how the court handles them and what the relationship is potentially between these two cases. Because although they're being argued a month or so apart, I assume the court will be thinking of them together.
That's great. Thanks, Shay. Do any of the other panelists want to offer any commentary before we move on to habeas and capital punishment? Anything? Shay, we might get a couple questions from the audience as we get toward the end. But now let's just go to Alexis, who's going to be talking about the death penalty in habeas areas. There are a couple of Ramirez cases already on the calendar, and the one she's going to talk about is Shimm versus Ramirez first, which involves whether a petitioner can introduce new evidence in federal court under ADEPA. It's with a paired case of Jones, and both are out of Arizona. And then she'll also talk about the Boston bomber case, Tsarnaev, and whether the jury media exposure and the court's exclusion of evidence during the penalty phase should have consequences here. Alexis?
Great, thanks, Joan. And I think, like Jen, I want to provide a framework for how we should be considering these cases. The justice system, in this country continues to administer the death penalty to poor people, people with mental health conditions, racially marginalized people, politically marginalized people, to people with deplorable trial counsel, and before juries where they are sentenced by biased individuals or where racial discrimination has occurred in impaneling the jury. We saw those cases most recently in the last two terms. And we'll see some of those issues in the three cases that Joan mentioned and that are before the court. So it's important for us that even as we talk about litigating these cases in court, of course, these are all before our high court, that we continue to push for abolition of the death penalty at both the federal level. So we have 49 individuals, 49 men that are currently on federal death row in Terre Haute, Indiana. And then in the 27 states where we still have capital punishment on the books. And that includes the three states, Oregon, Pennsylvania, and California, where we have governor instituted moratoria. So as Joan mentioned, we have Johar Tsarnaev's case, which is a federal death case. It's coming to us from the First Circuit. Shimm versus Ramirez and Jones. Those are consolidated cases litigated in Arizona state court that are dealing with federal habeas, the Anti-Terrorism and Effective Death Penalty Act. And then just briefly, I'll mention the other Ramirez case, which is another state death penalty case out of Texas, and that's Ramirez versus Collier. And I won't spend too much time on that last one. And Joan, I'm going to take some executive privilege here and touch on Tsarnaev's case first. Many of us are familiar with the underlying facts. It occurred in April 2013. We know right near the finish line of the annual Boston Marathon, 2 bombs detonated, killing 3 people and injuring many others, numerous others. So law enforcement very quickly zeroed in on the Tsarnaev brothers. So Tamerlan was 26 at the time, and Johar, who was 19. Tamerlan was killed shortly after by law enforcement officials, but the U.S. Attorney's Office in Boston prosecuted Johar. So in August, just last year, the First Circuit overturned the death sentence. They left the guilt conviction alone, and they focused on 2 issues. So in overturning that death sentence, they said that Tsarnaev's Sixth Amendment right to a fair trial was violated when the judge failed to adequately question each of the prospective jurors about the extent of their media exposure and then their potential for bias against Johar. So the court also held that the trial judge improperly excluded evidence during the sentencing hearing. And this was actually about his deceased brother. So Tamerlan was allegedly involved in a triple murder that occurred about 2 years before the bombing. And Tsarnaev's attorneys are arguing that if that information had come in the sentencing, it would have mitigated Johar's relative culpability. So DOJ asked SCOTUS to review the decision. The court seemed to delay granting cert until well after Biden was already in office. So this was conferenced several times throughout January, February. And as we know, Trump, at the very end of his term, presided over an unprecedented 13 federal executions. We hadn't seen that really in over a century. And while campaigning, we know that Biden promised to end the federal death penalty, hasn't done that yet. We see that AG Garland over the summer issued a memo saying that Department of Justice was going to be re-examining, reviewing its execution policy. But this is sort of all at a standstill, at least from the executive branch. So on October 13th, just next month, SCOTUS is going to hear oral argument on those 2 issues that I mentioned coming out of the First Circuit, which are the jury issue about exposure to media, and then whether or not this evidence should have come in that could have mitigated Johar's relative culpability. The decision will ideally give some guidance to trial judges on how to navigate voir dire in terms of media exposure. but I don't think we're really going to forge any new ground here. I do believe that a ruling could force Biden's hand on making a decision, again, regarding what we're doing with the federal death penalty. So where I want to focus my time and energy and attention for all of us to focus on is the Shimm versus Ramirez and Jones, and that's the case out of Arizona. Just today, we had amicus briefs filed by former Department of Justice officials and federal prosecutors saying that ruling against Mr. Ramirez and Jones would cause incalculable damage to public confidence in the criminal justice system. So this is coming from the Department of Justice, coming from former AUSAs. From former state and federal court judges. They are gravely concerned about this case. And they believe that a ruling against Ramirez and Jones in support of Arizona's position could make federal judges complicit in injustice. So what's going on in these cases? These differ from Tsarnaev's case in two major ways. It deals with AEDPA, the Anti-Terrorism and Effective Death Penalty Act, and it could have devastating implications on the way that our criminal trials run in this country, both capital and non-capital cases. So you have former Department of Justice judges all coming out in favor of Ramirez and Jones. I want to spend just a moment talking about AEDPA at the top of the hour. When Joan asked me, what am I looking for? I reminded us all how steeped in ideology and politics the court is. Well, those issues played a factor in the passage of AEDPA. And if we can remember, in 1996, in the wake of the Oklahoma City bombing, at the height on tough on crime legislation, then Senator Biden very much supported AEDPA, which essentially closed the window of relief for people who are incarcerated, both capital and non-capital people sentenced. And it really closed the window of relief for them to come into federal court and seek relief for federal constitutional violations that they argued had occurred in their trials. So I have to remind my students, I taught a class on capital post-conviction, what habeas corpus is supposed to be, because it barely exists in practice post-AEDPA. The Great Writ goes back to the Magna Carta and enabled people who had been convicted to come before the court and get relief. So in the simplest of terms, Ramirez and Jones presents the question of whether a person can properly be put to death without receiving a fair trial. That should give you pause. Arizona is asking SCOTUS to overturn unanimous panel decisions from the Ninth Circuit that grant relief to both Ramirez and Jones based on compelling evidence of innocence in Barry Jones's case and intellectual disability in David Ramirez's case. And remember, intellectual disability means you cannot be eligible for the death penalty. But both at the time, of course, were sentenced to death. Jones and Ramirez never had the opportunity to bring forth this evidence showing actual innocence, showing intellectual disability in state court because Arizona appointed them incompetent counsel, not just at the trial phase, but also at the state post-conviction phase. They never had a fair opportunity to bring forth this information through no fault of their own. So in Ramirez's case, he remains on death row despite evidence of his intellectual disability. In Mr. Jones's case, his federal habeas attorneys, this is after trial, after state post-conviction, they were able to investigate and present evidence undermining the state's theory, tying him to the murder, which involved a child victim. So a federal district court found the new evidence so compelling, it vacated not just his death sentence, but also his conviction. And it ordered Arizona to release or retry him. And then, of course, the Ninth Circuit in a unanimous panel affirmed. So Arizona is now urging the Supreme Court to adopt an extreme reading of the Anti-Terrorism and Effective Death Penalty Act, a reading that no court of appeal has ever adopted to bar federal courts from considering this kind of evidence. So those of us who litigate habeas, I know there's many folks out there, know that SCOTUS threw us all a lifeline in 2012 when it decided Martinez versus Ryan, which is another Arizona case, which Alito and Chief Justice Roberts joined. There, the Supreme Court held that although incarcerated people generally cannot assert claims in federal habeas that they failed to raise in state court, they may be able to raise ineffective assistance of trial counsel claims if the failure to raise such claims in state court was caused by ineffective assistance of state post-conviction counsel. Why is this relevant? Both Ramirez and Jones had ineffective assistance of counsel at both the trial and the state post-conviction level. But
Alexis, can I interrupt just for 1 second?
Please do.
You've nicely actually said what the letters stand for, the Anti-Terrorism and Effective Death Penalty Act, but we've gotten a question saying, why was it so restrictive? What's the burden that came to defendants because of it?
So there's this basic idea of federalism, of comity, and also an interest in finality, that when there is a death sentence, when there's a conviction in state court, we want to make it hard to overturn that. And so in theory, if you have effective counsel at trial, you can fairly litigate these issues. And there's some justice to be had. The conviction means what it means. But having spent over a decade representing people in federal habeas, there's really ineffective counsel. This is in violation of the Sixth Amendment right to counsel. And so the window has narrowed because under AEDPA, federal courts are prohibited generally from reviewing evidence and issues that have not been brought and litigated in state court. Again, these are basic concepts of federalism and comity between federal and state courts. There's a deference that federal courts give to state court. But in Martinez, there was an exception carved out that if an individual didn't have effective counsel at trial, didn't have effective counsel at state post-conviction, well, then how could they have raised these issues now that we're in federal court? For many petitioners, federal court was the first time they could investigate and present these certain claims. And that's what's going on with Ramirez and Jones. And this case, Shimm, Arizona, is asking the Supreme Court essentially to almost completely close that window and opportunity for relief. So I tell my students that AEDPA is supposed to be about, of course, these large issues, finality, comity, federalism. But here, Arizona's position in Ramirez and Jones prioritizes finality over all else, including justice and even common sense. Why in Martinez would you open the window and allow an exception to procedural default and then close it and prevent federal courts from even considering that new evidence that even allowed you to open the window in Martinez? So this case, again, could have ramifications, not just for death sentence individuals, but for anyone who's coming to federal court, who has been sentenced in state court and is seeking some sort of relief.
That's great. That really clarified things and helps to sort of set the table for the potential consequences of those cases. Do any of the panelists want to jump in before we get to the Second Amendment and gun regulation? Okay, we'll move along, and we've kind of carved out about 20 minutes at the end for additional questions that come up. But we're going to turn to Darrell now, and this case is revisiting the Second Amendment and exactly what the court said in the Milestone Heller case of 2008. It's New York State Rifle and Pistol Association versus Bruin. And the question is whether the Second Amendment right that was declared in Heller should be cabined for individuals in the home, as Justice Scalia suggested in part of his ruling, or if it could extend to carrying firearms outside the home, and just where does it go from there? So why don't you let us know what's at stake with that case, Darrell?
Sure, I'm happy to. I'll make this very quick. So I think it's fair to say that this is the Second Amendment case that gun rights advocates have been waiting for. So it's been over 10 years since the Supreme Court of the United States in District of Columbia versus Heller held that an individual has a right to keep an arm in the home for personal purposes like self-defense, unrelated to any participation in an organized militia. This was a watershed. No federal case had actually held this until 2008. And as I tell my students, before 2008, if you tried to make a Second Amendment argument about a personal right to have a firearm, you would be kicked out of court on a motion to dismiss. After 2008, you had a live right. But Heller and its subsequent case, McDonald versus the city of Chicago, which incorporated the Second Amendment to apply to states and localities, left a host of questions unanswered. Who has this right? The presumption in the Heller decision was that it was law-abiding citizens, but as Justice Breyer and Justice Stevens asked in their dissents, well, why this group? So litigation has percolated about, does it apply to minors, 18-year-olds? Do you have to be a violent felon as opposed to a non-violent felon to be prohibited from owning a firearm? What about undocumented immigrants? Do they have Second Amendment rights? Questions like what counts as an arm? Other than pistols, which is the regulation at issue in District of Columbia versus Heller, what about assault rifles? What about new technologies like people that want to put weapons on remote drones, for example? Does this count as an arm for purposes of the Second Amendment? Heller had clearly said that you could have a gun in the home for self-defense, but it was really unclear exactly how broad the right to keep and bear arms is. That is, does it stop at the doorstep? How far out does it go? And that's what the case of Bruen really presents. Bruen involves a challenge to the New York state licensing scheme for firearms. So to obtain a license in New York to a firearm, to carry it with you concealed, the licensing agency or agent, usually a local government official, has some discretion. And an applicant needs to show some kind of reason or necessity under one provision of the New York law to show good cause for carrying a gun, other than a simple assertion that I need it, or I feel vulnerable and I need it for self-defense. Now, this is the narrow doctrinal issue in Bruen, and it's a big one. A minority of the states have what are known as may issue. That's a may issue regime. That is, there is some discretion. The person that's applying for the license to carry a gun has to show some kind of a need different than the need of any other individual. It's a minority of states, but it's a large portion of the populace. So states like New York, California have may issue laws. And even though a minority of states might have may issue regimes, it still governs a lot of people, and a lot of people in states with big metropolitan areas. If we think of LA, New York City, San Francisco, etc. But I want to highlight what I think is an interesting sleeper issue in the Bruen case, which is the question about how does one even go about answering the question about whether something's constitutional or unconstitutional. So right now, the lower courts have adopted what's known as a two-step framework. This two-step framework asks an initial question about, are we even dealing with a Second Amendment question at all? It's a coverage question. So, for example, the person that pulls a gun on somebody to rob them doesn't have a claim that there's some sort of Second Amendment right to pull the gun on them, right? We're not even talking about a Second Amendment right in that context. Then, assuming that we are dealing with something that implicates the Second Amendment in some way, the second part of the two-step framework is what we might think of as a fairly conventional, what's known as tailoring analysis, strict intermediate scrutiny, where the government basically shows through some kind of empirical data or some kind of reasoning about why it has advanced this law, what purposes, what legitimate purposes it advances, and the courts look at this kind of tailoring. How close does it fit to the reasons that are proffered for the particular regulation? Many constitutional rights have this kind of structure of a coverage and then a kind of protection question. What's interesting about the Bruen case, and might be a signal about just how new this new conservative majority on the court is there is a wing of the court that seems committed to what's known as a text, history, and tradition only approach to this question. That is, The only way that you decide whether something is constitutional in the Second Amendment realm is by reference to text, history, and tradition and analogies therefrom. So, for example, in a conventional two-step framework, a regulation which didn't come up until the 1960s, for example, of carrying a firearm, a loaded firearm, in one's carry-on bag into a plane, would be done by reference to something like, are we dealing with a coverage question? And then, what are the dangers of firearms in the cabins of airplanes? What's the risk? You would have this kind of data. A text, history, and tradition only approach would say something like, that's not really a relevant factor. What's relevant is what kind of regulations in 1791, when the Second Amendment was enacted, look like a regulation of a gun in an airplane. And the issue there then becomes, if that is the mechanism by which we start litigating Second Amendment cases, it opens up a whole different kind of world with public law litigation in the gun rights, gun regulation space. Suddenly, everybody becomes antiquarians. We all have to find out, what kind of regulations existed in 1791. We do what I would say would be somewhat peculiar kind of analogy games, which would be like, well, is an airplane kind of like a boat? There were regulations in the 18th, 19th century about shooting guns off the decks of boats, and therefore this is like a boat. And in some ways makes the analysis really interesting from an academic viewpoint, but quite alien to the way people, I think, understand and live their experience of rights and regulation in the United States. Just as a matter of disclosure, because Shay had done the same thing, I and a couple of colleagues filed an amicus brief on behalf of neither party, basically advancing the idea that a strict text, history, and tradition and analogy only approach would be a mistake in terms of just the methodological issue. The arguments are set for November 3rd, and I think we'll get some indication during those oral arguments about where exactly the court is headed, both in terms of a result and in terms of a method of reasoning about the Second Amendment.
That's great. And I'm reminded as you talk about that framework of text, history, and tradition, just the competing views that we had back in Heller between Justice Scalia and Justice Stevens, both professing to take an originalist viewpoint and coming up with different outcomes. And I know Aaron probably remembers this only because he once clerked for Jay Wilkinson, Judge J. Harvey Wilkinson on the Fourth, but he took a similar approach, commenting on the Scalia opinion in Heller, just taking apart his view of the text. But I imagine that this is going to give the justices yet another opportunity to have those competing versions of exactly what did the framers say and how it's played out through the years. Do any of the other panelists want to talk about Bruin?
I'll jump in for a minute.
Sure.
Darrell, I'm curious on what you're referring to as the text, history, and tradition approach. If you had come across the amicus brief that was filed by Judge Ludig in this case, in which he argues that in Heller, there were no founding era statutes that regulated possession of handguns in the home. And so that was the key to that case. But here, legislatures have long restricted the carrying of loaded guns in most public places. And sure, you can find some scattered authorities to the contrary, but the overwhelming evidence is that there was a tradition of this kind of regulation, and that reflects the balance that the Second Amendment is really striking and letting legislatures strike between self-defense and public safety. I thought that was a noteworthy brief that may get attention on the court given its author. And I'm just wondering what you think of that in light of your criticisms of really the whole approach of even thinking of the question in terms of text, history, tradition that way.
It's an excellent question, and I two responses. One is that I am aware of this brief that former Judge Ludig filed. And it's of a piece with an opinion by Judge Bybee in the Ninth Circuit that held a gun regulation kind of using a text history and tradition approach. So one interesting aspect of it is what we might see as sort of divisions on what we might think of as, persons with sterling conservative credentials about the application of text history and tradition approaches to the Second Amendment. The second thing that I think is worth pondering about it is when we do that sort of text history and tradition, if it becomes the coin of the realm in Second Amendment adjudication, then the question is, at what level of generality, at what level of abstraction are we supposed to be thinking about this historical evidence? So what happens sometimes in the lower courts is you'll get what seems to be a fairly generous view about analogy at the level of protection. For example, an AR-15 didn't exist in 1791, but there's a kind of sense which that's an arm, and that's the level of abstraction that we're thinking about the protection for the thing. But then some judges deploy a very granular level of specificity on the regulation side. So it's not enough that you had a regulation in 1791 or even before that, that kind of regulates in the public interest for public safety. It's got to be a certain type of regulation of a certain type of specificity. And if it doesn't look like that, then the premise is, at least among gun rights advocates, that the regulation is novel and unconstitutional. And so your point is very well taken, which is the issue about regulating firearms and doing Second Amendment analysis through a text history tradition only approach really depends on whether we have agreement at what level of generality to look for such an analogy.
Can I just add one postscript there? One of our members of the audience says, what's the justification in the Second Amendment for the text history tradition approach, but not in the other amendments? And you might have mentioned that earlier, but we got that question.
Sure. So the quick answer is that there are some stray remarks, both in the oral arguments in Heller and in Justice Scalia's opinion, where Justice Scalia disparages Justice Breyer's dissent, where he says we should be doing some kind of balancing. What's the government interest in safety versus, the regulation here? How tight is the fit? And Justice Scalia, in his majority opinion in Heller, disparages that and says, well, look, that's just open-ended balancing. You're looking at government interest and you're balancing against rights, but rights are supposed to be there to keep them from being balanced away. Some of a certain generation, I think, of new judges sort of brought up in an originalist traditions now see that as not only taking on the specific type of balancing that Justice Breyer was suggesting, but the entire architecture of tiers of scrutiny, that you just don't do rational basis, intermediate, strict scrutiny anymore, because that always involves looking at the government interest and then doing some kind of balancing against the rights. And so there's a subset of the bench right now that sees that as totally judge empowering and illegitimate, and sees text history and tradition as somehow more constraining. And I think the real question is it more constraining, or is it just more obscure?
Got it. Finally, we'll turn to Aaron, who's going to do two cases, one that is already on the agenda and one that could be by the end of perhaps taken in January. And the first is Carson versus Macon, which presents the question of whether a state violates the religion clauses or the equal protection clause by prohibiting students who participate in an otherwise generally available student aid program from actually choosing to use their aid to attend schools that provide religious or sectarian instruction. A major question, given the emphasis of the majority over the years on religious liberty. And the other one, Aaron, if you could touch on before you finish, is the case that we're all looking to see what the Biden administration tells the court, since the court has asked for its views in the Harvard affirmative action case that's come up from the First Circuit, which challenges, the fundamentals of Bakke and Gritter, but comes up there on behalf, at least on paper, on behalf of Asian American students who might have been excluded from Harvard admissions. Go ahead, Aaron.
Sure. Thanks, Joan. So Carson versus Macon is a case about actually a fairly unique Maine statute, Maine law that governs public education. So in Maine, as is true in just a small number of other states like Vermont, state law gives public school districts in very sparsely populated rural areas a choice, right? Either you can set up a public high school of your own, like most school districts do, or if that's inconvenient, impractical, because there's just too few students, you can outsource it, right? You can write a check to the parents, and the parents can take that voucher, it's a school voucher, one of the earliest school voucher programs in America, right? And use it at a private school to enroll your child in a private high school. But if Maine says a school district does this second option, they outsource, right? The parent can only use their private school voucher at a non-sectarian school, right? A secular private school, not a religious one, right? And so the question in the cases Joan mentioned is whether that prohibition against a religious private school receiving the tuition voucher violates the free exercise clause. And I'll just tell you right now, because there's no reason hiding the ball, there's like zero mystery about how this case is going to end up. You can bet your house, your salary, whatever else you might want to bet, that Maine's going to lose. And it's going to lose almost certainly in a 6-3 party line vote. Because the court's going to hold that the free exercise clause prohibits Maine to provide funding only to secular, non-religious private schools. It has to provide, if it's going to provide this funding at all, to both religious and non-religious schools. So I'll just tell you a little bit about the reasoning for why I think this is the likely outcome, why it matters, and then I'll touch on the affirmative action case. Okay, so the main reason there's very little mystery is just 2 years ago, the Supreme Court held in a largely similar case out of Montana involving a Montana private school voucher program that also wanted to limit access to private religious schools, that violated the free exercise clause. Right, so that's bad for Maine. And Maine comes in and says, well, this is different. Montana's law discriminated, if at all, prohibited religious schools from receiving the voucher, these public funds, only on the basis of religious status, right? The court said if you were at all affiliated with a church or partly controlled by a church in the Montana case, you couldn't get, that's why Montana said you couldn't get the public funds. And the Supreme Court said that's unconstitutional. If you discriminated against private school on its religious status, free exercise violation. And Maine says, well, we're doing something different. Right? We actually have no problem with a religious school getting the voucher as long as it doesn't spend any money. It doesn't have any classes that engage in religious instruction. Right? If it's a church-run school, but if in all other ways it looks like a public school, they don't have a Bible study class, don't have religious themes in their instruction, they can participate. Right. And you can imagine why Maine might draw that distinction. Maine might care about an establishment clause concern, right? If public dollars are being used to educate children in religious instruction. So technically, the Supreme Court in the Montana case did reserve that question, whether the status or use of public dollars on religious education, whether that made a difference. But it's just very, very hard to imagine the six conservatives thinking that it does make a difference, right? It's hard to imagine them saying that it's okay to deny participation, what they would think is discrimination against a religious private school, just because they offer, a single Bible class in the school, but not that one that doesn't offer a Bible study class. And, in fairness, in their defense, right, the free exercise clause does protect the exercise of religion, the active exercise of religion, and not just the status of religion. Okay, so why does this case matter? So I want to make the suggestion that the real pain point, the real reason this case is dangerous, may have less to do with sort of the legal question presented around free exercise, and may have something more to do with a different issue that isn't often talked about. right? Now, I want to, of course, acknowledge that some people will be worried about the Establishment Clause concerns, public dollars being used on religious instruction. And I don't want to downplay or diminish that legitimate concern. But the truth is that argument has been off the table for 20 years, right? In 2002, the Supreme Court already said, as long as private parents have a choice where to send their kids. They don't have to send the kid to a religious school. If they choose to send it to a private secular school, there's no Establishment Clause concern, right? The state's not coercing or trying to indoctrinate any children that doesn't want, or for whom the parents don't want their kid to go to that religious school. But I think what's more worrisome is that a pro-religious school ruling in this case is going to lead to public dollars going to religious schools that engage in blatant discrimination of their own against LGBTQ students, right? So just to illustrate, I took a second to look at the student handbook of Bangor Christian School, which is the major school that many of the plaintiffs in this case would like their children to go to, a religious Christian school. And here's their student handbook, front and center on their own website. They declare, quote, "We believe that any type of sexual identity that lies outside of the one man, one woman definition of marriage, including those that are becoming more accepted in culture and the courts, are sinful perversions. Any deviation from the sexual identity that God created will not be accepted." Right? That's the kind of school that wants money from the state of Maine to educate children. And I just think there's more than a bit of irony, cruel irony, in my opinion, when private religious schools are arguing that a state voucher program is unconstitutionally discriminating against them when they're themselves engaged in blatant discrimination on the basis of LGBTQ status. Okay, so if there's good news in this case, it's that this is a problem that we can address via statute, right? After it loses this case, Maine could pass a law saying, okay, free exercise clause requires us to allow religious schools to receive private school vouchers, the vouchers that were these checks that we're writing to the parents. But no school, whether you're secular or religious, can discriminate, refuse to enroll, deny admission to a student on the basis of LGBTQ status. Right? That would, to be clear, raise its own free exercise question under Smith. As long as that case is still good law, it's on shaky footing of its own, the state would likely prevail as long as the law is truly neutral in that way. All right, I'll say a quick word about the affirmative action case, which is students versus fair admissions versus Harvard. As Joan said, the question is whether the college's use of race, Harvard's use of race in its admissions procedures violates the Equal Protection Clause. There's strong reason to think that the court is going to hold eventually that it does. There were already 4 votes to overturn Grutter and Backey. Then Justice Kennedy retired and Justice Ginsburg passed away. But I think the short answer for this term is that it's not going to happen this term, right? The challengers filed their cert petition in February, as Joan mentioned. The court called for the views of the Solicitor General under the Biden administration just in June. Which is a really odd move. I don't think anyone thinks the SG's office under a Biden administration is going to tell the court to just overrule Grutter and eviscerate affirmative action. And I don't think anyone thinks that the 6 conservative justices on the court really cares what the Biden administration thinks about affirmative action. So what that means is that move to call for the views of the Solicitor General was like the puntiest of punts. The court just doesn't want another colossal, culture wars case on its docket this term. The standard turnaround for a CVSG is like 6 months, but it can take up to a year. So I think it's more likely that the Biden administration says, sometime next spring, court should deny review, this issue splitless, it's settled. Conservative justices say, actually, we want to take it up anyways, and it'll be the case that we're all talking about this time next fall.
Thanks, Aaron. Let me ask you, we've been able to hit most of the questions that have been coming in, but there's one that came in on the Indian Child Welfare Act, a question of the racial preferences and whether they violate equal protection. Are you familiar with the case? It's pending, and the response. Yeah,
I'm wildly familiar. I think what case? It's the out of the Fifth Circuit. I actually had my students do a hypo on it. Yeah, it's a really interesting question. I think I saw the question, right? So ICWA creates a procedure under which before a state can take a child with Native American heritage away from the Native parents and place them with a non-Native couple for adoption purposes or foster care purposes, the state has to engage in sort of a heightened set of procedures. They have to do more to obtain evidence to make sure that the Indian family had a chance to show they were really, not negligent, they were fit parents, right? And the reason for this, there's very good reason for this. for most of American history, states were taking children away from tribes and placing them with white families to assimilate them, right? And so ICWA is a response to that sort of sordid history, just to make sure before we take these children that the parents really are unfit, right? Because there's an interest on the other side. If there's truly a child who's in danger, we do want to remove them. And there's a question whether this is racial discrimination or discrimination on the basis of national origin in violation of the Equal Protection Clause, because it singles out children for Native children for special treatment. The real issue, though, in the case, the legal argument is not around Equal Protection Clause so much as it's around commandeering doctrine and whether this law forces state officials in violation of the 10th Amendment to take certain actions that the government can't force them to do. I'll just leave it at that because it's really in the weeds. But it's a big case and a big question.
That's great. Actually, the timing could potentially be for this term, but that sounds like another one that if they were to take it, they might not want to do it right away with everything else pending. I am bound and determined to finish this right at 3:30. So I'm going to ask a couple questions to kind of a lightning round here based on what we've got in. And one first to Jennifer that has to do with the consequences if the justices do overrule Roe and Casey. Do you see something on the horizon then for like Loving and Lawrence v. Texas? I mean, how far could this go in terms of due process?
Well, it's a really good question. It'll depend on how the justices write the opinion, but that's exactly right. That a ruling that if there is no right to abortion, then it really calls into question whether the courts would also go after things like the next one would be contraception, right? And looking at Griswold and Eisenstadt and going on down the line. So that is a real question based on how the courts write their opinion.
Okay. Another question that's come in, a lot of people in this audience care about court expansion, term limits and things like that. And one of the questions, Alexis, has been, can you imagine what ruling or series of rulings that would really prompt the public, prompt Congress to truly want to either expand the court or impose any kind of term limits? I mean, do you see anything coming down the pipe?
A ruling on any of these issues. All of these cases that we've talked about are the hot button issues. And this isn't the first time that court packing has been a response from the public to a collection of cases that comes out in a way that one segment, one end of the political spectrum doesn't agree with. So both Roosevelt's presidents tried to pack the court. FDR got a little further along than Teddy Roosevelt, and it really did political damage to the Democratic Party. They lost a number of seats in the Senate and the House of Representatives. And so I think that, in the short term, court packing seems like a great solution, a quick fix. But one political party isn't always in power. And so if the Democrats change the law so that we can pack the court, then the Republicans have the opportunity to also pack the court. So I think it's a short, quick-sighted fix, and we've seen the way 100 years ago that it played out. And I don't know that it's a solution that would solve our problems.
May I just jump in, Joan? And
of course.
I agree so much with what Alexis just said, but I want to tie Alexis' point back to something Jennifer said at the very beginning, which is just because court packing is a really, really dangerous idea, unless you like the idea of 6 more Sam Alitos 10, 20 years from now on the court, doesn't mean we're out of options. Jennifer is absolutely right? The worst case scenario for progressives this term is Roe is overruled. Abortion rights are totally gutted. That's by far the worst case scenario. But jumping to court packing, abolishing the filibuster to pack the court, seems like it sort of misses the more obvious solution, which is the Women's Health Protection Act, right? Anything you can do by abolishing the filibuster in the Senate to pack the court, you can in theory do by abolishing the filibuster, at least on this issue, to pass a law pretty well grounded in the Commerce Clause, because this is an economic transaction we're talking about, making a federal statutory right, no matter what state you live in, to have access to safe abortion. That seems like the better solution, at least on this one issue.
Can I just weigh in on that? Because that assumes that there is some kind of, you have two minority sort of empowering institutions. You've got the court, which is the sort of, its center of gravity is different from the center of gravity of the populace as a whole. And then you have the Senate. and the Senate's, overrepresentation of, rural, more conservative states. So Aaron, your point would make brilliant. It would make good sense if you could actually get such a regulation past the filibuster. But if you can't, then you're essentially icing in the decision, and there is no legislative fix because the legislative fix itself is subject to holdouts by a minority position in Congress.
Yeah, I don't disagree with that. I was just saying if we have the power to pack the court, I would rather use that power on an issue by issue basis to save voting rights, to reenact Section 5, to pass the Women's Health Protection Act. But you may well be right that we don't have the power to do any of this, in which case our best option is to go out and vote and win some damn elections.
Okay, we'll go from the macro to the micro now. One member of our audience commented that it was impressive that Darrell knew the brief that Shay mentioned, Ludig's, his former boss. Of all the amicus briefs filed, how does one know which briefs are going to be influential, which ones to focus on? And we've got two former clerks here, but we also have plenty of people who spend a lot of time writing amicus briefs trying to get their attention. Shay, you want to start, and then we can have a couple others jump in?
Sure. I hate to say it this way, but it's almost like you know it when you see it. There are just some briefs that, based on the name of the organization, the lawyers on the brief, whether it's a strange bedfellows kind of brief, will just catch your eye. And I think as a clerk, you look at all of them, but nonetheless, there are some that are going to stand out more. And certainly as an observer of the court, there are some that stand out more just based on those sorts of factors. Like I would expect the clerks would always pick up the ACLU brief. They would probably also always pick up a Institute for Justice brief as well, just because those are known quantities to the court. And so I think the nature of the organization matters, the lawyers matter. And as I said, strange bedfellows sometimes can get attention.
Can I highlight one interesting thing about the briefing?
Yeah.
So just really quickly, one of the interesting things is at the same time that you have, especially among Republicans in Congress, a full assault on critical race theory and the idea of implicit bias. There's a remarkable set of briefs by conservatives, including a large percentage of the Republicans in Congress, saying just that about gun regulations. Gun regulations have disparate impacts on communities of color. This is really about the carceral state and putting people in jail. It's really, really interesting. I don't think that when it comes to voting rights or other kinds of things, the kind of concern that they have for the disparate impacts on people of color really play out the same way as they do when it has to do with gun rights.
Anyone else before? I'm going to turn the program back to Russ, but I just want to thank everyone who offered their expertise here. And we've gotten a few more questions and lots of comments in the chat. So thanks to Alexis, Aaron, Darrell, and Jennifer, and Shay, and Russ, take it back.
Joan, wonderful job. It was a fantastic panel. And if you found this conversation meaningful, as I certainly did, please take a minute before you sign off to consider joining ACS. We've just dropped into the chat a link that will enable you to become a member. As we mobilize our network to take on the challenging issues addressed by the panel today, we need you to join in this fight. There's strength in numbers. We need you now. This is a call to everyone to join ACS. So we encourage you all to become a member today. And thanks so much to everybody who participated and all the people who attended. And I wish you a good evening. Thank you.